a good discussion of the geopolitical elements of that practice area. We're moving on to one of my favorite topics, which is involving the examination of where we've been and where we're going on what some of us still call NAFTA. Now it's called the USMCA. And if you're Canadian, it's Kuzma. And if you're Mexican, it's Musca. So, but we have come into the second generation of North American free trade. And the question is, and our moderator will, I guess, characterize this in his questioning in the discussion about, what are we looking for in the coming months and years with the current geopolitical situation, which, of course, we're all experts in that area and we talk about it a lot, but I think you're going to enjoy this panel greatly. So let me start off by introducing our moderator. We are honored to have Paul Levine moderating this second panel. He's a partner at Baker Hostetler and co-head of their investor state arbitration group here in Washington, D.C. He focuses his practice on international disputes and arbitration, asset recovery and enforcement of arbitration awards and court judgments, as well as being involved in complex litigation. Paul is a first chair counsel and has helped recover and enforce judgments worth millions of dollars for clients in the US and worldwide. And he has a lot of experience in ISDS and is particularly energized on this topic, I know. So without further ado, I'll pass the microphone to Paul and we'll get going on our NAFTA 3.0 panel. Thanks, Paul.
Thank you very much. I just want to thank the organizers of Washington Arbitration Week, Jose Antonio and all their support staff for making a great conference. This gets better year by year, so we look forward to future participation in it. Without further ado, this is about NAFTA 3.0. The North American Free Trade Agreement, it was a landmark treaty for the United States, Canada, and Mexico. And the genesis for that treaty came as early as Ronald Reagan, who wanted an integrated North American free trade zone. That led to a free trade agreement between the United States and Canada, and ultimately NAFTA being signed and ratified in the early 1990s, only after some significant opposition in the United States and Canada. But in a sign of quainter times in the United States, Bill Clinton, the first George Bush, Gerald Ford, and Jimmy Carter, they all attended the signing ceremony, touting the treaty's likely economic impact to the United States through encouraging free trade with two of its biggest trading partners. All of that proved to be true and more. NAFTA also included what we would term as a modern investor-state dispute settlement chapter. It had an explicit statute of limitations. It defined who the investors are and the investments with some more specificity. It allowed the treaty partners to issue interpretations of what the treaty meant. There could be explicit non-disputing party statements and many, many more features. And despite involving just 3 countries, NAFTA led to approximately 75 known claims, according to the public research that I did. And that actually seemed slow to me. But what seemed like a landmark in 1993 was deemed outdated in 2017 when President Trump in the United States decided that NAFTA was too one-sided against the country. In its wake came a new treaty, the United States-Mexico-Canada Agreement, better known here as USMCA. There were various updates to the trade-based provisions and significantly for a panel for Washington Arbitration Week, a complete overhaul of the investor state dispute settlement chapter, which severely limited potential claims. Another feature of the treaty was an administrative review process after 6 years and a 16-year treaty period, unlike the open-ended NAFTA. That means this administration will be able to renegotiate the treaty that it negotiated in the first place. All this begs the question of what is the future for a free trade agreement in North America, the future for investor-state treaty claims amongst the North American countries, and really the future of ISDS generally in these countries and elsewhere worldwide. With me to discuss these pressing questions is a fantastic panel with a depth of experience on NAFTA and the USMCA so that we can consider the implications of what comes next. I'd like to introduce the speakers. Todd Weiler is an independent arbitrator and barrister who specializes in foreign investment and trade disputes. As a pioneer in the field of investment treaty arbitration, Dr. Weiler has amassed over 25 years of experience serving as co-counsel, testifying expert, consulting expert, and arbitrator in many dozens of international disputes, which have involved an extensive array of clients, countries, economic sectors, and dispute settlement fora. His name has also appeared on the Who's Who legal list of leading international arbitration lawyers since 2007. Dr. Weiler joined Arbitra International in 2021 as part of his transition into serving exclusively as an arbitrator in international commercial and public international law cases, in addition to continuing his work as consulting expert in foreign investment protection matters. Todd seemingly was there at the beginning of NAFTA, not really, but seemingly. So he has a special perspective to lend to this discussion. Lauren Mandell is an attorney at Wilmer, Hale in Washington, D.C., and a lecturer in law at Columbia Law School. Lauren's practice spans both international trade and arbitration. On the trade side, Lauren helps companies navigate tariffs, supply chain challenges, digital trade, trade negotiations, and many other issues. On the arbitration side, Lauren represents both states and investors in ISDS matters. Prior to his current roles, Lauren served for 6 years as a senior lawyer and negotiator at the Office of the U.S. Trade Representative under the Obama and the first Trump administrations. At USTR, Lauren acted for the U.S. as the U.S. government's lead negotiator in the USMCA investment chapter negotiations. He also negotiated investment rules in the CPTPP, the TTIP, the U.S.-China BIT, and many other agreements. Kristen Young is a partner at Willkie and Farr and Gallagher in D.C. She maintains a global practice focused on international investment treaty and commercial arbitration, with a particular focus on complex energy, mining, and infrastructure disputes. Her experience includes investor-state arbitration under numerous bilateral investment treaties, the Energy Charter Treaty, CPTPP, TPP, DR-CAFTA, USMCA, and NAFTA. She has taught arbitration courses at Georgetown, University of Chicago, University of Richmond, and Tashkent State University of Law in Uzbekistan. I think that's the farthest one anybody had to travel to. And she is currently acting on the first arbitration to proceed under the CPTPP. And last but certainly not least, Aristeo López is a special legal consultant in Clark Hill's international trade and arbitration practice. Before joining Clark Hill, Aristeo served for 15 years in the Office of the Legal Consultant on International Trade at Mexico's Ministry of Economy. From 2014 to 2021, Aristeo served as a counselor at the Mexican Embassy in Washington, D.C., where he negotiated the investment and government procurement chapters of the CPTPP and the USMCA. Aristeo also acted as counsel for Mexico in multiple investment arbitrations under NAFTA Chapter 11 and bilateral investment agreements. So with that, let's start the panel. And we'll start here with a little history lesson with Todd. NAFTA, when it was executed in the early 1990s, it was a big deal to remove these trade barriers across the United States, North Mexico, and Canada. So if we just go beyond the ISDS section, how important was NAFTA when it was executed? And what do you consider the legacy of NAFTA to be?
Thanks. I should mention, since I never finished it, I actually have got a Malbert dissertation on a doctorate in international economic law and history. So I'm actually an amateur historian too. So hopefully I will sound like one still. I think it's important to mention that while Reagan definitely did get the ball rolling, he got the ball rolling with Mulrooney, and it gave us the Canada-US Free Trade Agreement. And the Canada-US Free Trade Agreement was an essential part of further integrating the US and Canadian economies. It also had this very cool mechanism that would seem to tamp down to a certain extent the use of trade remedy law. So that's countervailing duties and subsidies. What's the other word I'm looking for? Anti-dumping laws. The mechanism was you could either use whatever international mechanism you want to challenge a finding, or you could go domestically wherever you would normally go. So the US ITC and US Court of Trade, or the Canadian versions. And so if you went domestically, then you knew what was going to go on. But if you went internationally under this treaty, the people you got to do it, basically all the panelists were academics and trade lawyers. And so the academics and trade lawyers, here in the exact same case, under the exact same domestic rules, could come to different conclusions, and eventually did develop a body that was more pro-trade, less protectionist as a result. The Canadians loved that so much that was one of the primary things they wanted to keep, not just in the NAFTA, but also in whatever 2.0 is called. This was crucial to them to keep this mechanism because they thought they had so much success with it. I mean, with regard to the NAFTA, what's interesting is Canada was not there at the beginning at all itself, but rather was knocking on the door asking to be let in because they had heard about how Mexico and the US were looking at having their own free trade agreement. And the Canadians were concerned there might be a hub and spoke system developed where all the benefits of trade come to the country in the middle that has all the separate deals. So to prevent that, they barged their way in. But luckily, still at that time, that would have been Mulrooney and the senior Bush, and they got along really well because so did Reagan and Mulrooney. And so they let him in. And what's funny about that is ISDS wasn't even contemplated in the US-Canada Free Trade Agreement. It was contemplated in the NAFTA already. And the Canadians just basically looked at it and thought, sure, why not? We've got investments in Mexico, so we need protection from Mexico too. So they had no problem signing on to it. They might have missed the fine print where it said that those obligations ran both ways. But that was essentially, the Canadians were like, fine, we're happy to do that. It's the American model that basically, therefore, is what you see in the in NAFTA. But the key function of NAFTA, of course, might be not legal, but political. From an economic political standpoint, it was a crucial part of the Mulrooney regimes, the Mulrooney governments, the successive governments' drive to change Canada from a closed protectionist economy into a more thriving open economy through imposition of a value-added tax, through getting rid of a lot of other taxes, and by having this NAFTA, which would require much more competition. And of course, better competition means better prices, more advancement. So it was crucial for Canada. There was a very, very important election, not on NAFTA, but the previous one on the Canada-US free trade. That was our big election. That's where we had the two parties really finding it out. And it was a close election, but arguably it was won on other issues. But and then the Americans, of course, you had your big election with when Ross Perot pops up. And in that case, you had to deal with all that tension. The Mexicans, was interesting is I remember Hugo Perescano-Diaz is one of the negotiators of the NAFTA, and then for many years the lead lawyer for the NAFTA Mexican NAFTA team. He said that his government was very much in favor of the dispute settlement mechanisms in ISDS because they thought this would be a really good way to bring discipline to Mexican decision making, including courts. So it seems like when you look at it, ideologically, all three governments were pretty much aligned, classically liberal for the most part, and they all saw these mechanisms as a way to help them achieve more domestically to reform than they otherwise would have been able to do. And of course, from an economic standpoint, we know the numbers were great. It helped all three countries tremendously boost GDP. So it all had that wonderful effect. And one way of saying how you had a consensus at the time is to note that by the time the NAFTA was signed, Bill Clinton had taken over from the Bush team. Jean Chrétien had taken over from the Mulroney team. And yet they both signed the treaty that their previous governments of a different party had signed. So it shows just how much consensus there had been, or I guess as the Trumpy people would say, the one governmentness of it. But I think that's, that's a lack of ideology talking rather than too much. So this was obviously, therefore, in conclusion, this was a very important development. No less so, of course, is this new development. The only question is it developing in a way that is still classically economically liberal?
So we're at Washington Arbitration Week, and so
I thought it was in Ottawa already.
I know, and I want to drill down a little bit into the features of NAFTA, which, as I described earlier, was considered a modern treaty. And what are some of the features of the treaty that you think were added to that treaty that are now considered standard to be applied elsewhere? And what's going to be the legacy and the principles that really last from the NAFTA treaty that will go beyond NAFTA itself?
Well, of course, I've already mentioned one, this binational dispute settlement system, which ebbs and flows in importance depending on the extent to which each country is using those tools, which of course they're very nature protectionist, but are also baked into the system. I'm reminded of something I didn't mention, and might have also mentioned, was the other big thing about the NAFTA negotiations is that they were used as a counterpose to drive the WTO negotiations. So the NAFTA negotiations and the whole movement of the NAFTA really provided a pathway for where the WTO negotiations could go. And once again, really obviously showing that classical economic liberalism was, with different characteristics, was the main motion. So what's the other, politically, of course, we've discussed it. What the only other legacy I think that we want to cover would be investor-state arbitration. And in investor-state arbitration, important things to note there would be that early on, when the first folks started complaining about it, like Bill Moyer is one of them, I remember, and Ralph Nader's people or another, it had the adverse effect because I found within the first 10 years of our practice, Ian and I were both pioneers, if you will. It was really fun because if you had a creative mind and you read the newspaper or read more than one newspaper every day, you could find cases that nobody else saw. Like you had to be good at explaining them to the people who also didn't know they had a case because they didn't see the angle. And I have to admit, the person we worked for, Barry Appleton, I think he was first in seeing that this wasn't just really a chapter about bonds and stocks. Reading it fully, it was a much bigger chapter than that. The trade flavor of some of the earlier cases may have to do with the fact that I was trained as a trade lawyer, but nonetheless, the cases were there, and some of them were quite successful. The reason I mentioned that Moyer or Nader was because their protest actually helped get more publicity for the fact that this mechanism existed. And that a lot, because for at least the first 10 years, nobody was doing it except for a few firms, key US and British firms that had old international arbitration departments, and therefore they could see all of this from an expropriation standpoint. They saw expropriation and certainly could bring cases, but there was more than just expropriation here. The fair and equitable treatment, which I have a whole book on, that was my doctorate in law, and full protection and security as well, and also national treatment. Those three concepts you can trace way far back. If you want to read the book, you don't have to do it yourself. You can just read how I traced it far back. And these ones became really crucial, so much so you know that they were crucial because by 2001, the three NAFTA governments, the lawyer teams for the three NAFTA governments were starting to try to engage mechanisms that would allow them to try to limit interpretations of, for example, Article 1105(1), which was the fair and equitable provision. So you knew it was working. They would say, on the other hand, though, that there were rogue tribunals going too far or what have you. But you know, the thing about text is text says what it says in context, and that's, you know, that's how we do our business as lawyers. So that was the big thing. It took about 10 years, and we got to give credit to Argentina's crisis because the Argentinian crisis was just a couple years down the road. The Argentinian crisis and all the cases that flowed from that, and the NAFTA cases, which were becoming more and more known, they are what gave us today investor-state dispute settlement as a actual, you know, legitimate practice. If those two things hadn't happened close, almost coterminous, who knows how big it would be? It might still be dormant. But it was because of that that we all got work, which I remember at the time was really cool because pretty much if you wanted to do international economic law, you either had to become an academic or you had to go work for the government. Those were the choices. Because the people who were doing arbitration, international arbitration, even the expropriation disputes, they were commercial lawyers. They weren't public international lawyers. They came from a different stream. So it was very interesting to see how that stream, I thought eventually one would win out of the other, but they didn't. What eventually happened is they joined and they both did it. But really important for creating a practice that brings us to the fact that we can celebrate Washington Arbitration Week, I'd say.
Kristen, what were some of the landmark NAFTA decisions that you think will still have relevance today?
First of all, NAFTA awards continue to.
There we go. I'll restart. Thanks, Paul. As we all know, NAFTA awards continue to be cited worldwide by tribunals. And I think the continuing legacy of those cases are for a number of reasons. As we were just discussing, this was sort of the first real body of law that came out of these types of treaties, but it was also available publicly for the most part. So, right. So as a very junior arbitration associate, I started my practice in 2007. This was the body of law available to you, right? So if you're looking for what's out there on the minimum standard of treatment, what's out there on expropriation, these were the cases that you were going to, and I think you still go to those. And particularly when you look at standards evolution, you go back to those original cases. And you can see even tribunals today are citing those sort of as the first principle in interpreting current standards. And so, to think about what are some of the NAFTA greatest hits, I think we all look at waste management too when we're talking about the minimum standard of treatment, a fair and equitable treatment. Obviously there's some refinements over the years on that standard, but I think you see that quote there pretty frequently in cases talking about that standard. Of course, what I'm talking about is it's quite a long paragraph, but really the key terms are that the conduct is arbitrary, grossly unfair, unjust, idiosyncratic, discriminatory, exposes a claimant to sectional or racial prejudice, or involves a lack of due process leading to an outcome which offends judicial propriety. You see that language really repeated in many decisions when we're talking about the MST standard. Another case that comes up very frequently, I'm sure most people in the room know this case, Methanex, a leading authority on police powers and on non-compensable regulation. The other reason why it comes up pretty frequently is that it had an assessment of the admissibility of unlawfully obtained evidence. And the circumstances are quite colorful and colorful, because in that case, there was a situation in which evidence was procured via trespass into a dumpster, and the tribunal ruled that evidence so obtained was not in accord with law and therefore not admissible in that arbitration. And that standard comes up pretty frequently, including in a case that I litigated at Whiting case, EDF versus Romania. The other thing Methanex is notable for, of course, is that it opened the door to amici. So you had amici participation and document access, and that has now been codified in various rules and now is a standard part of, well, the CPTPP for sure, the USMCA, and other US model fits and processes. Metalclad, another one that comes up very frequently, of course, on the issue of regulatory measures is indirect expropriation. SD Myers on national treatment, and Mandell and Lowen on denial of justice and exhaustion requirements. These are all cases we go back to and read and inform the outcomes of cases even today.
Just want to add, Thunderbird Gaming, I'd like to add, just because, well, it's one of my cases. Legitimate expectation. That was the first time we had that and got something with that.
Yeah.
Meyer, and Pope and Talbot with Myers. Sorry.
Yeah, no, absolutely.
And then last stop on our history tour, Aristeo, can you sum up the Mexican attitude towards NAFTA 1.0 after its 20 plus years of jurisprudence and just existence as a treaty?
Yeah, of course. I mean, I think it was really nice to remember all these anecdotes from Todd and looking at the past. And as Todd mentioned, I mean, that back then the Mexican government was really convinced that the investment chapter was going to be like an essential tool for Mexico to attract more investment. And I think they were right. I mean, it increased the investment in Mexico dramatically. But also for Mexico was kind of walking into a dark zone, because as Todd mentioned also, I mean, for Mexico, Mexico had no experience in these cases. Since the first case, Mexico faced Robert Asinian, I guess was the first one. I mean, the Mexican team, was kind of new into this area. So over the time, over the years, the case law, as also Kristen mentioned, has developed into a very robust case law under NAFTA, and that's have helped to influence not only NAFTA tribunals that came later on, but also other treaties. That's something that perhaps we are going to discuss later today, and Kristen also already mentioned. Because the NAFTA legacy not only lives in the USMCA, but it's also spread across many, many other treaties. Such, for instance, I can set up the CPTPP, we have mentioned already, the CAFTA-DR, and many other treaties that the US has negotiated with the Latin American countries, but also that Mexico has negotiated with other countries, because that's another important thing. Not only the US has this US investment agreement model, but also Mexico and Canada to some extent started or continue to negotiate standards similar to the ones we have in NAFTA. So the legacy of NAFTA cannot be denied in terms of how much it has influenced other agreements and tribunals that settle disputes under different treaties, even to that extent. I will only mention, now that we are talking about important cases, other relevant landmark cases that we have to recognize also, as Robert Arsenian, the first NAFTA award, or the first consolidation tribunal for the three fructose cases against Mexico, and also the FTC note that not only discuss or clarify the obligations on MST, but also transparency. Back then, transparency was not even an issue in investment arbitration, and NAFTA parties decided to address those two important depth. So I think that's part of we can spend a lot of time talking about the NAFTA, legacy of NAFTA, but I think this is like a few relevant parts or points that I would like to make, and of course, how those influence Mexico's practice in years later.
We're very lucky to have a few people who were in the room when it happened. And so, Lauren, can you explain to us why, from the US perspective, NAFTA was redone into what's now known as USMCA, depending on where you're located?
Aristeo and I were both in the room. It was a crowded room at the time, but happy to talk. And thank you, Paul, and thank you to my fellow co-panelists. The end of the NAFTA was officially in 2018, but even from the beginning of NAFTA, and Paul, I think you highlighted this in your opening comments, NAFTA was a controversial agreement in the United States. I was a child of the 80s. I remember very clearly the 1992 presidential debates. Ross Perot, independent candidate, talking about the sucking sound, the giant sucking sound of jobs that would go south to Mexico. And that controversy, that public attention and scrutiny shadowed the whole history of the NAFTA. In the United States, the NAFTA was viewed by many Democrats and a smaller number of Republicans as contributing to the loss of manufacturing jobs overseas into Mexico, of course, particularly from states that were important in US presidential politics. It's looking at Ohio, Michigan, Pennsylvania, et cetera. President Obama in 2008, many will recall, campaigned on a promise to renegotiate the NAFTA. And depending upon one's perspective, he arguably did that in the TPP negotiations. But everyone knows on the first day of the Trump administration in 2017, President Trump decided to withdraw the United States from the agreement. And rather than look to a new mega regional agreement to replace the TPP or some other initiative, the president moved very quickly to focus on the NAFTA. And he called it the worst trade deal ever. Very innovative trade deal, sorry, Todd and others who were there, worst trade deal ever. In addition to the sort of politics of NAFTA, President Trump was very focused on the issue of manufacturing jobs, I mentioned, focused on trade deficits, the fact that Mexico and Canada were selling a lot more into the United States than they were buying. This was especially the case in the auto sector, which we may talk about later on. Autos really drove, in some respects, the negotiation of the NAFTA and also the negotiation of the USMCA, and may also drive this current review process that's going on now. And just one more comment on the sort of circumstances and the urgency. Ambassador Robert Lighthizer was USTR under the first Trump administration. He was sworn in on May 15th of 2017. 3 days later, on May 18th, he sent a letter to Congress announcing an intention to renegotiate the agreement. So this was the highest trade priority in the early days of Trump 1.
So what was the reaction in Mexico and Canada to the potential change to the treaty?
Would of course love the take from Aristeo. My take, from the negotiating table at the time was that it was negative. It was especially negative with respect to our neighbors to the north, who had spent many years, negotiating the TPP with the United States, and then to be told we're withdrawing, and oh, by the way, you have to come back to the table and renegotiate the terms yet again. I think in the negotiations at the very beginning and all through the negotiations, the president used the threat of terminating the NAFTA as a lever to force Mexico and Canada to the table, and also to extract concessions in the negotiations. And that went on all the way through till the end of the negotiations.
So, want to comment on that?
Yeah, I mean, just to answer your question, I think Mexico and Canada were shocked when the U.S. just basically explained the position on ISDS and investment, on investment, basically. When we were in the table, I mean, everybody, but there was a silence once the United States presented this position. Because, I mean, the three countries have had a long relationship and kind of a coordination in terms of being actively participating in NAFTA tribunals and kind of always, I mean, CPTPP, which was the previous treaty, the three countries were aligning also in terms of interest in pushing towards having NAFTA standards reflected in the CPTPP. And years later, I mean, you sit down with the US and the US position was dramatically different. So that's why I say shock. We were shocked at that time.
In Canada, the Trudeau government at the time was probably the most social democratic government Canada has ever had. So they actually weren't, at least at the political level, my understanding is they weren't too, too sad about the possibility that invested arbitration might be gone. In fact, I think that they were quite happy. The minister at the time, I recall, having a personal dislike for it. So that unfortunately, that made it pretty easy. Although I still think that the seriousness with which the higher level political people took any of this has to be questioned, in that Trudeau, how long he actually put off his TPP partners, even after they gave in and said, fine, you can call it comprehensive and progressive. And so just the unseriousness and signaling approach, I think I'd be interested to hear, I mean, whether that trickled down into the actual negotiations, or did the people I imagine the people you dealt with seem serious, but I'm not sure that their political masters were.
No, I think the Canadians were in a very difficult position in the negotiations, both politically having to be essentially bullied into the negotiations. And then at the technical level, we had the NAFTA that we were ostensibly renegotiating, but we also had the TPP and lots of other intervening practice amongst the three governments. I thought the Canadian negotiators were absolutely serious. I think, I know we're maybe jumping ahead a little bit, but on the question of, are we going to have ISDS in the agreement? Are we going to have ISDS that looks something like NAFTA, something like the CETA, the Canada-EU agreement, which had been negotiated in the intervening years? Those sorts of questions were hanging over the USMCA negotiations. I think that at the end of the day, I should make this point. I think Canada did not have a sort of firm position on, from my perspective, what kind of ISDS and when. At some point in the negotiations, I think Chrystia Freeland, the trade minister at the time, and along with the prime minister, made the decision that if we can weasel our way out of ISDS, we should do so. They saw an opportunity with Ambassador Robert Lighthizer position, I'll talk about, which was very critical of ISDS. And at the end of the day, they were successful in, I say weaseling out, pejorative, not intended. I'll take
it.
Yeah.
Well, because I think they were weasels.
Yeah. Well, I think this is on the record. But I was amused as a negotiator at the end of the process that Canada sort of declared victory of, we won a dramatic concession from the United States. Suffice it to say, that wasn't how I viewed it from a negotiating perspective. I think that the United States was more than happy at the end of the day to have no ISDS with Canada for reasons that we can talk about.
Well, go ahead. Why don't you just talk about those reasons? Why did the United States think that, we could get rid of the ISDS chapter?
Yeah. Well,
and just adding, what about the Chapter 19 stuff? Because all I heard in the Canadian press really was not about Chapter 11. It was about Chapter 19, whether or not they could keep their special binational panels.
Yeah, I would pass on the 19 question just because I don't have the personal knowledge of the dynamics. With respect to former Chapter 11, which became Chapter 9 on investment, it was a very unusual negotiation, clearly, and I'll make a couple of comments and observations. I think at the outset of the negotiations, the United States did not have a position. We had the model bit of 2012, we had the TPP, we had the NAFTA, we had all of this precedent, and yet at the beginning of the negotiations, and Aristeo will remember this well, unlike I think every other US trade or investment negotiation, US walked in on day one and said, what do you guys want? Rather than this is what we want. And the reason for that is because at the very outset, I mentioned Ambassador Robert Lighthizer. He took over as USTR in May. He had very strong personal reservations against ISDS. There's a lot of color here, but I would just say on the substance, offensively, he viewed ISDS as against the US interest because in his view, it facilitated or subsidized the movement of manufacturing jobs in particular to Mexico and to other jurisdictions. And then defensively, he really loathed the idea that US laws or regulations or court decisions could be subject to review in an international tribunal. And so I think, and he was able to persuade the president, he was able to persuade Congress that these concerns, these criticisms of ISDS were well put. And at the end of the day, informed sort of the U.S. position. At the end of the day, I don't know if it's useful to talk about what we ended up with, but we ended up with an agreement unlike any other with Annex 14C, which is the legacy claims, which I think others will talk about, allowing claims under NAFTA rules and procedures for 3 years after USMCA entry into force. We already talked about Canada, that Canada did not have ISDS with Mexico or the United States under the agreement. Canada had and still has ISDS with Mexico under the CPTPP. And then into the weeds of Annexes 14D and 14E. Annex 14D, in the NAFTA world, every investor, every sector, full access to ISDS, no exhaustion requirements, no requirements to litigate in the domestic courts of Mexico or Canada. Now we change the world, right? We have investors divided into different types of groups, effectively. Most investors, in my view, have essentially no meaningful access to ISDS. They have to jump through procedural hoops to access ISDS. They have to litigate in, let's say, Mexico, in the courts of Mexico for as long as 30 months before bringing a claim. They only have access to a narrow band of claims, national treatment, MFN, direct expro. And then 14E, the different class of investors, this was what in the negotiations we referred to as the kind of the keyhole provisions, that if an investor, I'll take the example of a US investor in Mexico, has a certain type of contract in a certain type of sector, and so a covered government contract in certain sectors, including oil and gas, power generation, transportation, they have full traditional access to ISDS. And so that's the landscape now as between the three countries under the USMCA.
Aristeo, do you want to care to comment a little bit on Mexico's attitude to the change in the ISDS chapter in NAFTA?
Sure. I mean, I think what I can say is that looking at this from the perspective of what happened since NAFTA was negotiated, I mean, ironically, when NAFTA was negotiated in the 90s, I mean, Mexico was under pressure to accept the investment chapter to some extent. I mean, Mexico was not too convinced about having an investment chapter, ISDS, too. 25 years later, when we negotiated the NAFTA and the USMCA, positions were dramatically changed again. I mean, the US was the one who wasn't in a position to accept ISDS, whereas Mexico was pushing towards having an ISDS, continue with NAFTA, with the NAFTA legacy. And I think that throughout the negotiation, Mexico had that position expressed that position very clear. But however, as just Lauren mentioned, I mean, we ended up with a different result. But however, I mean, if you ask me why Mexico agree on having these annexes with the US that just Lauren mentioned, and not with Canada, I mean, I think that this basically because of what I said. I mean, Mexico has was very proactive in terms of having some form of ISDS. And I guess the balance in the end is better to have something than not having it. I guess in the end, just like Canada had a different perspective, Mexico has its own. And I think that explains a little bit why Mexico's position during this negotiation with the US and Canada.
And so let's talk about the legacy claims. As we talked about earlier, there was a 3-year overlap sunset period to deal with prior NAFTA claims. What's the status of those claims, Kristen?
Yeah, sure. Let me just talk really briefly on what a legacy NAFTA claim is. So these claims, there was a mechanism established in the USMCA Annex 14C that essentially provided this short-lived bridge that allowed qualifying investors to continue to use NAFTA's Chapter 11 procedures for pre-USMCA investments during a 3-year sunset period. That bridge is now closed. And the consent to legacy claims expired on July 1, 2023, 3 years after the NAFTA ended on June 30, 2020. A lot of those cases are still outstanding and are currently being litigated before tribunals. Some have come out with awards. There is, of course, a question as to temporality, this open temporality question on whether you can challenge under this legacy framework measures undertaken by a NAFTA member state during that sunset period, so during the consent window, can you challenge that? Or are you limited to claims that arose pursuant to actions taken before the consent period, so before June 30, 2020? That case, this issue, of course, came up in the Keystone TC Energy versus United States. And the position taken by the NAFTA member states on that is, of course, no, you can't do so. And that's because the NAFTA obligations themselves, so the treaty obligations that are imposed on the parties, those ceased to exist on June 30, 2020. And at that point in time, the USMCA picked up. So the obligations that were imposed on the states as of that date were uniquely USMCA. Of course, you could bring a NAFTA Chapter 11 claim based on conduct that occurred while the NAFTA remained in effect. So before June 30, 2020, those, of course, you were able to bring under the NAFTA legacy provisions. But if you're dealing with uniquely conduct that arose post termination of the NAFTA, you must then seek redress under the USMCA and not under the legacy NAFTA. Now, that question is, of course, been decided by the TC Energy Tribunal, but it's the subject of a number of other jurisdictional objections that are currently being litigated now. And so to be determined whether other tribunals follow that approach, but certainly the NAFTA member states have, I think, all taken the position that you must have conduct that predated the termination of the NAFTA.
Do you agree with that interpretation?
No.
No surprise.
Ian and I are co-counsel in a case involving the government of Alberta, which was a large investor in the Keystone project, and we just had a hearing. So the matter is sub judice. I wouldn't want to therefore speak too much about it. I think I would just read the first paragraph of Legacy Investment Claims Annex 14C, which says, each party consents with respect to a legacy investment to the submission of a claim to arbitration in accordance with Section B of Chapter 11 of the NAFTA, and this annex alleging breach of an obligation under, and then the obligations mentioned are ones in the NAFTA. I think if you just give that to anybody, the plain reading of this text is really straightforward. It was a grandfathering period that was going to give you 3 years of extra protection, after which you'd be stuck with whatever the new treaty had. And I won't go into any more detail about the opposing arguments, but let's just say they involve, you got to get a bunch of experts on international law to change what you think certain words mean. I'll probably just leave it at that. Anyway, but yeah, so there's.
I think the argument goes a little something like, you of course have a sunset period during which you could bring a claim, but the protections themselves, right, the obligations that are imposed on the states cease to exist as of termination. And so as a matter of international law, you do not have a claim that is crystallized because you no longer have the protections that are accorded to you by international law under those treaties. But I think that's the argument.
No, I think it is the argument. Of course, the problem with it, I think, would be just like a renvoi or to law or any kind of legislation by reference, including treaty lawmaking by reference. I think that there's a temporal issue involved in that, which would essentially require one. If one's referring to this stuff as of this moment, then it doesn't matter if after that deal has been done, we don't now look at the obligations. Oh, well, it's not an obligation anymore. It was an obligation as of the moment that the agreement was made and that the reference was made to that text would be my response to that. But yes, it's all about whether or not the substantive protection continued for 3 more years or just a right to bring a claim that would have therefore had to have been before.
Right. Yeah, I think the other open question.
I wonder if these two guys have anything to say about it.
I was just going to say the other open question to be determined is when you're dealing with an action that begins when the NAFTA was enforced and then continued, so a continuous breach that would have spanned both time periods, right? And how you treat that. And that's an open question in a couple of cases that remain pending. But how do you judge that and whether you determine?
So we've talked about where we came from NAFTA 1.0. We talked about currently where we are, NAFTA 2.0. So let's talk about NAFTA 3.0, where we're going to go. And I feel like it was just yesterday, we were just doing NAFTA 2.0 with President Trump. And now here we are doing NAFTA 3.0 with President Trump. Why are we even here? And like, where are we going to end up going? Lauren, you're probably the best place to say
And how do
that.
you tariff movies?
I think that's an easier question to answer than the question that Paul asked of how did we get here and where are we going? I'll offer a few comments. And I think, Paul, in your introduction, you previewed this kind of sunset provision that was included in the USMCA. I don't mean to keep referencing him, but this was another innovation from Ambassador Robert Lighthizer. He took the view, which he said publicly at the time, that trade agreements last forever, but our economies change, technology changes, our needs and interests change, our politics change. And so shouldn't we take a different conception? And so in the USMCA, he initially proposed 4 years and it's done, meaning 4 years automatic termination of the agreement. Aristeo, I'm sure, can speak to the Mexican reaction to that. Canadian, shocking, I think, is an understatement. This agreement that had really underpinned enormous integration between the three economies. Now you're saying that we're going to renegotiate it, and then that's over after 4 years. We have to start over again. Where we ended up is a much more convoluted and complex, I would say, in terms of an approach. July 1st, 2026 is the 6-year birthday of the USMCA. The three countries under the agreement are expected to come together in what's called a joint review of the agreement to look at how the agreement has performed, to look at does it need to be modified, and also to look at the question of should it be extended. And the way this works, and I hope this is clear, if all three parties on July 1st, 2026, agree to extend the agreement is extended for a further 16 years. And then the parties will see each other again in 6 years, in 2032, to continue whether, again, to agree to extend it for another 16 years. If the one party does not agree in next summer to extend the agreement, not to say that it wants to stop the agreement, but it just does not agree affirmatively to extend the agreement, the three parties must return the following year, July 1st, 2027, to have another joint review. And then again and again and again. And if for 10 consecutive years, 10 consecutive July 1sts, there is not consensus to extend the agreement, then the agreement terminates on July 1st, 2036. The caveat here is that if at any time in one of those reviews you have consensus, all three parties say, let's go, well, then you have extension for 16 years and an agreement to come back together again in 6 years. So it's very obvious and clear how we came to this decision, I'm sure. It's very logical and simple. But I think the most important thing now is, what does this review look like, right? That we have never had, I think in the history of trade agreements and treaty drafting, a process quite like this. A couple of questions that I ask. One question, will, on the US side, will President Trump want the agreement to continue or not? You have just seen yesterday, when Prime Minister Carney was here, the president say to the press, I'm not really concerned about it, that either it continues, renegotiate it, we have separate agreements with Mexico and Canada. I think it's very unclear, what the president wants here. The other question, regardless of whether, the president wants to continue the agreement or not, it will have at least 10 more years. In the course of these 10 years, is this review process going to look more like a sort of, a bonsai tree, clipping here, clipping there, or is it going to be something more like a renegotiation? There are different views on that question. I think that, sort of my gut instinct is that it does look a bit more like a renegotiation than a perfunctory review, if only because, from the Trump administration perspective, there's real leverage here to get further concessions from Mexico and Canada, either things that the U.S. thought they got in USMCA and they're concerned about compliance, or new things that have evolved in terms of U.S. interests. Final comment, though, I think regardless of whether this is a review or a full-on renegotiation, there's at least one issue that the United States will want to address very badly. And candidly, this was an issue that would have been the case whether it was Trump, a Harris presidency, a Biden presidency. I think it's a bipartisan issue in the United States, and that is the idea of making sure that third country content, in particular content from China, does not get the benefit of the preferences in the agreement. And this is it goes into the world of tariffs and rules of origin, not investment, but just suffice it to say for this discussion that right now under the USMCA, you can have a good that is manufactured, assembled in Mexico that has as much as 35% Chinese content, for example, that can still be regarded as a good of Mexico that benefits from zero tariffs under the USMCA. And I think in the 6 years since USMCA was negotiated, there is a bipartisan view, not a uniform view, but a bipartisan view that is too permissive, and that the NAFTA and even more so the USMCA have allowed this sort of loophole to allow other countries to take advantage of the rules in the agreement. And so again, I think it's going to be a U.S. priority, and we'll see what Mexico and Canada say on this issue.
Aristeo, what's Mexico going to say on this issue, do you think?
No, I mean, I think I agree pretty much with what Lauren says. I mean, Mexico is going to be kind of forced to enter into this uncertainty because, I mean, as Lauren mentioned, when the USMCA was negotiating, there was an intention to make a distinction between negotiation, renegotiation, and review. And that's why because we were trying to put some safeguards to prevent from any party to open in the Pandora box and review the treaty again. However, we are in that scenario now, regardless of what the treaty says. And now Mexico will have to face, and Canada will have to face this reality and get prepared for this renegotiation next year, potentially a renegotiation.
So, Kristen, an investor wants to bring a claim under what used to be NAFTA. What are their options right now? Like, what are their options? Obviously, NAFTA is not, or USMCA is really not a viable option for most investors. What do you do?
Well, as I think Lauren was hinting earlier, your options are much more limited, particularly if you are a U.S. investor with an investment in Canada or Mexico. So looking at Canada first, as Lauren mentioned, Canada does not join the USMCA's investor state arbitration mechanism. So if you are an investor in Canada and you're a U.S. company, you do not have an ISDS mechanism available to you. The legacy window was the last opportunity you had to seek ISDS against Canada. The Canada-Mexico, you still have recourse under the CPTPP, which we'll, I think, come to later in the discussions, but that treaty provides for an ISDS mechanism between Canada and Mexico. So if you're a Canadian investor, you have a claim against Mexico, you can proceed under the CPTPP, which has very similar protections, some of them slightly narrower, but very similar protections to the original NAFTA. Now, if you are a US investor in Mexico, you do have a mechanism available to you under the USMCA Chapter 14, but as Lauren mentioned, it's quite narrow and very different. And ultimately, it's not robust in any way, shape, or form as the original NAFTA provisions. And that's because, as Lauren was mentioning, you have these very narrow distinctions between different classes of investors. And so even in a situation where you may have a claim for national treatment or MFN or direct expropriation, you have to pursue this 30 months of local litigation first. And then in this other category, if you have a covered government contract in specific sectors, oil and gas, power generation, telecoms, transportation, and certain infrastructure, you have broader access, and no local litigation requirements, but the nature of your investment is quite specific and narrow. So it doesn't apply in the same way. It's the whole class of investors typically protected under a treaty. So it's a very different structure and it requires, frankly, some planning if you are investing in these countries and want to avail yourselves of these options in the event of a dispute. You have to really think about how you structure that investment pre-dispute to give yourselves protections.
What about the claims under the CPTPP? What do you think is going to happen to that treaty going forward in light of the further NAFTA joint review process and the negotiation of the treaty or USMCA?
Well, what's interesting about the CPTPP is that it's an agreement among 12 economies, right? So it's not just Mexico and Canada, although there are some cases now proceeding where you have a Canadian investor against Mexico under the CPTPP, which I'm involved in. But you have Australia, Brunei, Canada, Chile, Japan, Malaysia, Mexico, New Zealand, Peru, Singapore, Vietnam, and now most recently the United Kingdom. So you have a fair number of states that are signed onto this treaty, which provide pretty robust protection. So I think this is going to pick up, in my view, from these older treaties, and provide access to arbitration where it used to be available under the NAFTA, and now you have the CPTPP. And if you read the CPTPP, many of the provisions are either copied almost directly or very much inspired by the original NAFTA text, the DR CAFTA text. And so it's very familiar to people who have arbitrated under those treaties. The language is quite familiar. So I think we'll continue to see cases under the CPTPP, particularly in view of what's happened on the US.
So I guess this leads to the ultimate question as to what I think a lot of ISDS practitioners are going to want to know is, what is the loss of the ISDS provisions in the NAFTA treaty? What does that signal about the future of ISDS and just the NAFTA countries generally and potentially elsewhere? And I just want to start with Lauren. I don't think it's a surprise that the Democratic administrations have been somewhat hostile to ISDS. You can read the comments from different Democratic senators and see that, and see some of the renegotiations or reinterpretations of treaties. You've commented it was a little bit of surprise for some of the Republican administrations to not like that, the ISDS chapter. And so given this landscape, what do you predict is the future of ISDS in the United States, bearing in mind that it's almost been a net win for the United States for their investors elsewhere, and they've never suffered an adverse decision against them?
It is an important question. I think we're in, maybe it's cliche to say it, but in a bit of an inflection point for ISDS and the protection of foreign investment in the United States. Maybe I'll offer a couple of thoughts. I think that in 2025, for both Democrats and Republicans, there are, I think, arguments that may appeal on the merits of ISDS. And I'm not going to distinguish amongst the parties here, but there are arguments around the advancement of the rule of law. There are arguments around competition with China in terms of enabling U.S. investors to compete against the Belt and Road projects and that sort of thing. There are arguments around access to critical minerals, which is a priority for both parties. Arguments around resilient and safe supply chains, dependable supply chains. You can make these arguments, but certainly the politics around ISDS are not favorable at the moment. Candidly, I think there are some in Capitol Hill that sort of view ISDS as an almost an issue that's passed, right? That maybe they didn't live through the TPP debates, the other debates, and they view ISDS as an issue that didn't that end in USMCA. I've heard that question raised. In terms of the future here in the United States, I think it again on the politics, I think it largely depends on does U.S. industry prioritize this issue or not? I think one of the reasons why ISDS has sort of fallen a level in this country is because when you look at the first Trump administration, the team came in, Robert Lighthizer came in, and they were just going after sacred cows left and right. They were threatening the WTO. They were threatening to terminate the NAFTA. Companies, industries in the United States, I think, had bigger fish to fry in their view. There were some sectors, some companies, I think, for which investment protection ISDS remained sort of a top 5 or even a top 3 or top 1 issue, but those were few and far between. I think when you look forward, what does it look like? And I think with Mexico in particular, things have changed in Mexico in the last 6 years. I think the judicial reform has raised questions about the independence of Mexico's courts. You have a lot of investors now, sort of the post-legacy claims period, who find their claims, their disputes unresolved and potentially unresolvable through international means and maybe even through diplomatic means. And so you can see, the sort of the factors that could lead U.S. companies to want to sort of really push for ISDS in the USMCA and in other countries as well. But I think and I want to be clear, I'm not passing judgment here. I think companies and industries, they need to make careful calculations in terms of how to spend and use their resources and political capital. But I think it really is that question of, we've lost something now. How do we react to that? Do we feel that, well, it wasn't worth the cost, or do we fight for it?
Aristeo, what's the Mexican attitude right now towards ISDS, and how does the loss of ISDS in just the USMCA treaty reflect on its future in Mexico?
Yeah, I mean, I'm not very optimistic about the investment chapter. Unfortunately, I mean, as I mentioned, Mexico used to have a very proactive, offensive interest in having an investment chapter with ISDS provisions. But now I think I perceive that the Mexican government has more moderate interest to the extent that perhaps they will be happy with what they have right now under the USMCA to continue with the ISDS provisions we have. And actually, I recall some of my former colleagues at the Ministry of Economy regarded the investment chapter under the USMCA as the best ISDS mechanism that Mexico has negotiated. So that tells you a lot about the sentiment in Mexico. Perhaps that's my perception. And if Mexico is no longer too interested in having a strong ISDS mechanism like we used to have in NAFTA, the US is not going to change its position, I think. And Canada has no interest in having ISDS as we have it in NAFTA. I think that is very easy to conclude that perhaps we're going to have the same text after the review, or even a little bit worse, I say, because President Trump announced yesterday that perhaps the best way to go in the review is by having 2 bilateral agreements. And if that's the case, that would be a complete divorce from or departure from Canada from the investment chapter. And that will just let Mexico and the US with this kind of ISDS mechanism that will continue over the next years. So that's more or less my forecast.
All right.
But but just one comment. Yeah. The only hope that I see is that if there's the interest and by the industry, as Lauren said, I mean, if the industry really put some pressure on the government, the US or even Mexico to highlight the importance of having ISDS as a way to give certainty to foreign investment. I think that's the only hope I can see in this process.
So, Todd, as our resident Canadian here, obviously Canada.
Don't say resident.
No, that's right. Yeah. That's right.
I'm just visiting. It's on
a visiting Canadian on the panel.
Business
Sorry.
Visa. Yeah.
As our Canadian on the panel, you see that the ISDS chapter, which is no longer with the United States, but there's still some protections vis-a-vis investments in Mexico under the CPTPP. How does this inconsistent framework reflect upon Canadian attitudes towards ISDS and its future in the country?
Lots of thoughts. See how quickly I can go through them. I would note first thing, we don't have a 301 law in Canada, so even the avenue where Canadian government you'd think might be able to complain on behalf of a Canadian investor. That also, even if we had a 301, we don't have a history of that kind of thing. So it really is dead in that regard. Although I still, when we say the word concessions, that the US is getting concessions, that just reminds me of my trade law days. I mean, concessions are funny things in trade law because the best thing you could possibly do in a trade negotiation is surrender everything and have no tariffs and say, okay, whatever you idiots want to do. Our consumers are going to be happier and eventually more productive. So it's funny that we still have that that problem. By the way, if anyone wants, got someone they know who's going to law school, or is a law school professor, I think a class on a course on rules of origin would be a really good idea. So, because I have a customs background, so that I have a little, maybe I'll do that course. We'll see. With regard to Carney, when Carney came here, they were really tamping down anything happening, and they were really playing up the security angle. And I wonder what that's going to look like, and what sort of quote unquote deal happens if it becomes, of course, because normally, traditionally, you don't mix up a trade negotiation with, or how much military commitment are you going to have? But I think that might be going on, which really makes it harder, I think, to understand, but I guess some hope, which of course is a big problem, because ultimately, I have to wonder from a political perspective, not a lawyer, as a political perspective, why bother with a trade treaty when your counterparty seems to have very little problem breaking the rules they just signed? So I mean, that's just an open question. And maybe just how do lawyers deal with that? A little tidbit: if a Pierre Poilievre government had gotten to power, from talks I had with some of the aspirants who would have been probably cabinet ministers, I'm pretty sure you would have seen a much more traditional approach to investor state arbitration and the value of it as a protection. It's just, unfortunately, they didn't win because this big, something happened, and it scared people a bit older than me, and they're the ones that vote the most. So unfortunately, it didn't happen. Ian's very happy about it, though. And finally, let's see here. Don't expect the industry pressure. That's not going to help. It hasn't helped all these years because nobody wants. It's just like a wedding. You know, when you get married, you don't want to talk about the prenup. Well, when you're doing business, you don't want to talk about the disputes. So who's going to spend their capital? Say, only maybe national resources companies. And the other query we have to think about as we go forward is, can the existing lattice work of treaties, which is in the thousands, can it survive without the US driving the bus forward and always being there as a, well, for one, even in the negotiations and the UNCITRAL, to kind of poo-poo the idea of these courts, but rather pushing arbitration. Without the US doing what it's done for 80 years, can that system survive? But if it can't survive without them, well, then there will still be work. It's just going to be there. And then the final thought is a historian's thought. It was something that kind of motivates the dissertation I haven't written. If you go back right up to about, let's say, the mid-19th century until now, and you can draw a sine wave. So it's not a perfectly even sine wave, but you can draw a sine wave that goes between statism and liberalism in the zeitgeist at the international level. You can trace it. It's in each time when, for example, when the WTO got done, when the NAFTA got done, we were still in a good place because we were in a liberalism period. But we were just coming out of it by the time the MIA happened, the Multilateral Agreement on Investment. It didn't happen because of that. And you can actually trace back other multilateral movements going way back. It's just that right now we're in a big statism period, really big. And that statism could be any kind of statism, because ideologically it doesn't really matter if, how you come to the fact that the state should be more involved in society and including the economy. We just have to wait until the rule of law, private property and freedom become more valuable again in our general zeitgeist. Hopefully these treaties can survive until that happens.
And then Kristen, just for you to sum up, what do you think, given these attitudes with NAFTA and the ISDS debates in the United States, Mexico, and Canada, what's that signal for the future of ISDS just, worldwide? Like I hear a lot of pessimistic things here, and I'm probably amongst that chorus.
But we might be dead.
Well, that's not helpful.
Yeah, well, I mean, and frankly, it's picking up on what Tom was just saying. I think the United States' retreat from a broad ISDS framework is just accelerating what was already happening, the shift that was already happening underway globally. And that was away from open-ended investor-state arbitration towards a more narrowly tailored, more transparent, and often more state-controlled dispute mechanism. And so I think the result of that is not an end to ISDS at large, but a more fragmented cabin system with sharper differences by region, sector, and treaty vintage, right? So you'll have this patchwork, but I don't think it's dead. And I don't think the US retreating from that very broad ISDS view signals the end. And I think a good example is the fact that the United Kingdom signed on to the CPTPP in December 2024. I mean, that treaty is moving. It has now a new member. And I think that's a good example of, the US, of course, never signed on. And so it continues to have force and to gain new member states. But I think as an investor, what this all means is that in terms of your diligence at the outset, you need to consider treaty mapping, treaty planning, careful analysis, ongoing as to are your protections shifting because of these revisions of protections and treaties, and making sure that you do have an appropriate mechanism in the event of a dispute. And considering, look, also commercial arbitration options. Are you in a situation where the opportunity to bring investor state a case against your host state might be quite limited, or maybe it requires you to have 30 months of local court litigation. And so in that instance, maybe it's better to have a commercial arbitration option, maybe a clause in your concession contract, et cetera, that gives you a similar type of neutral form in which to bring your case that might not be investor state, but yet gets you to the same result. So I think really for investors, it's that key diligence that's happening either at the outset of your investment or as you're implementing that investment going forward.
I'm looking for the statutes too, like the domestic investment protection statutes.
Right. And whether you can avail yourself of those,
too.
and whether it gives you direct access to arbitration as opposed to just a general.
Yeah, good feeling.
Yes.
Well, I'll thank the panel very much and open it up to questions from the audience.
Lauren, you mentioned it briefly. But my question is for both you and Aristeo. How is the judicial reform going to, in Mexico, going to impact the USMCA revisions, and whether is that is going to change a little bit the mindset of the Trump administration towards ISDS with Mexico?
I have the same question. I think all that we know at this point is that the Biden administration, including the US ambassador to Mexico, was highly critical of the judicial reform and raised very public questions about the impact on US commerce and US investment. The current USTR ambassador, Jameson Greer, Secretary of State, Marco Rubio, and others have also raised very serious questions. I think it's going to shadow the discussions, not just around the investment chapter of the USMCA, but around the viability of the trade agreement, right? That obviously all sides are going to have to look at the agreement and determine, can it deliver on its promise? And if there is a view that the independence of Mexican courts is in question, I think it raises real questions on well beyond investment, on the trade agreement, on other forms of bilateral engagement.
I agree with Lauren's comment. I mean, it's a very good question, and that's something that can change things next year, depending on how these interests go. From the perspective of Mexico's perspective, I mean, I would say that there's no interest, as I mentioned, in going beyond what we have right now under the USMCA. So it all depends on what the U.S. interests decide to go for.
And fortunately, we're out of time. There's another panel soon thereafter, but I want to thank the panelists. Thank you very much for a wonderful discussion and about where we've been, what we're dealing with now, and where we're going to go. So thanks to everyone.
Thank you for the moderation.